Hello, everybody. It's all set up. It's all working. It's going. I'm so excited. I can move to the side and you can see Billy. You can see Ava. Probably a lot more clearly than before. I'm so happy to be here. Oh my gosh. It was so crazy. I got the new computer yesterday. I had no audio, no sound at all. And so I couldn't look up cases, I couldn't edit, I couldn't do anything on it. So I did the troubleshooting thing and I ended up with Microsoft Teams support, and they remote controlled my computer for an hour and 45 minutes. And I got like sent to a level 2 engineer, and they tried deleting some driver that they said was causing the issue. They crashed my whole system. I didn't even own the dang thing for a full day before they crashed my whole system. It went blue screen with a sideways smiley face, or sideways sad face, and it said, and there was a warning too, mind you, that popped up before she deleted that driver that said not to delete the driver. And she did it anyways, and boom, it all went bye-bye. No, hey, you guys, no, we are not fighting. Yeah, no, we're not. Um, so yeah. And then plus the monitor that I got, I went from a 10.5-inch monitor. I said I wanted a small one. They sent me a 27-inch screen. It was bigger than most TVs I've ever owned. Hi, Earl. Earl, please don't start nothing. So, yeah, and then the webcam to be on the top of the computer screen, I was like this the whole time. I'm like, this isn't going to work. The only angle you saw was like the top of my head or my bed. Like I'd have to quit my YouTube career and become some kind of a fangirl in order for that to work. It was horrible. But it's all fixed now. I got myself down to it's a beautiful. Stop, Ava. I know you're jealous. The kitties are here. You want your attention. Give me 2 seconds. My goodness. I got myself down to a 24-inch, I think it is. But yeah, I couldn't look at the camera, and then I tried getting a bracketron and like sticking it to my desk, but it was on the side, so then I'd have been like side-eyeing you all night, or turned like that. No, it was awful. Okay, if you move your fat butt, I'll get to the drawer. So it's all set up. There's still some stuff I have to do. Like I don't have all my files. Can I please close the drawer? I don't have all my files moved over. So much to Salty Buddha's delight, I won't have the PAWFURM intro tonight. So Salty Buddha will thank me later, I'm sure. You just chill. You act like you haven't eaten all day, and I can vouch for the fact that you have. This can vouch for the fact that you have. All right. Oh my gosh. I'm so happy to be here. I took a little nap after I got everything set up, so I should be wide awake. My gosh. She's so cute. Hello, Nana Laura. Hello, she's a maker. This is a twofer. Wait. This is a twofer. Out of here. Hello, C-Rex, honey. Hello, Lisa Peanuts. Hello, Linda Applegate. I you hadn't seen me yet. I still so what she's making a jokes about is Nana Laura said, "Hello, gorgeous April," and I told her, "I've got a 4K camera now. You may be taking that back." So Linda Applegate is she's being funny. Hello, Eileen Carlin, honey. Hello, Ginny. I don't know how to fix that yet. I will figure it out. I'm sure it's going to require playing around with an app for settings or something. Yeah, I don't know. I kind of noticed the haziness too, just slightly. But I will be working on. I also have to get the app put on here for the Yeti Blue microphone, because apparently that fixes sound quality issues if you have the app. My old computer didn't have enough memory to support having those apps. So now that I have a new computer, I can do things like that. Yeah, once I get, set up completely, I'll fix things. This is the first run. Give me a break. Give me a break. I don't know. I don't know. It's supposed to be autocorrective to all that stuff, but beats me. I plug it in and turn it on. That's what I do. Hello, Spider-Man. Good to see you, love. Honey. Oh my goodness. I was gone for a couple hours today. I don't think she knows how to cope. She's just beside herself. Mommy wasn't here to pet her every minute of every day for one whole day. I know, she's special. Come on, baby. Come on, your fan club calls. Hello, Mary Hill. Thank you so much. They definitely appreciate the love, as you can see. They're super spoiled. Hello, Sherry B, honey. Hello, Shane. Hello, Charlie. Welcome, love. Brian Buggo. Hello, Brian Boggs. I love you. Oh, you're killing me. You're killing me. You're killing me. I don't know what to do. All right, you got to just bear with me. Bear with me. I'll play it back when I start the case. I'll play it back and I'll see how horrible it is, and then I'll push buttons and I'll see if I can fix it. I love you guys. Thank you for letting me know, though, because I can't fix it if I don't know. Hold up. Ah, come on. No, stop. I hate when they change things. Oh, so you guys remember this dude, right? There, this guy. So tonight, the first case is his sentencing. So we're going to see the update to the I'm Not a Monster case. And then we're going to go into a 2-hearing FTC. It's catch me if you can. Well, catch him if you can. You can catch me. I don't run very fast. Yeah. Yeah, we'll go with that. I'm close enough. I'm close enough to Gen X that, that I can claim technology issues still. The home pick is rather too bright. Like the main, what you see now, I will find a way to adjust settings. It's just not going to happen this moment. So we're going to have to put up with all of the issues for tonight. And then tomorrow, hopefully, will be better. Okay? Someone else said overexposed. I think overexposed is when it's too bright. But I don't like there's no buttons on it. Like there's nothing I can do on the camera. It's going to have to be like app settings. So we'll just have to. All right. That maybe when I transported it. Hold on. Oh my goodness. I've got too much going on here at the moment. Hold on. I'm trying to turn my mic around. Let me see. Okay, Brian, you're the genius on okay, so I don't know what gain does. There's a dial that says gain, and then there is the figure 8 or the full bubble. Well, thank you. So I changed the gain a little bit, and okay, well, how is it now? Is it any better? I will fix it as soon as I can, honey. All right, so volume's a whole separate thing. But is that any better, Brian Boggs, as far as audio goes? Hello, Donald Westerdale. Oh, hi, matey. Okay, I will. Thank you. Alrighty, guys, let's get into it. Please, Ava, please stop. Don't look at me with those big, beautiful brown eyes.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas.
Wait. Oh, it didn't. Oh, it didn't. Ava, stop, please. It didn't remove the picture, but when I put the case on, start this again.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Gage Douglas Apple. It's case number 2024 CR 341. Brett Sweeney appears on behalf of the state of Kansas. Chris Pate, as defense counsel, defendant Gage Apple appears from a Zoom location at the Butler County Detention Facility. This matter comes before the court at this time for sentencing, where its docket notes indicate that on January 21 of 2025, Mr. Apple appeared before this court and pled no contest to an amended count 1 aggravated battery, a level 4 person felony, and count 2, aggravated assault, a level 7 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a completed pre-sentence report compiled by pre-sentence investigator Ryan Smith, who is present on this meeting with us. I trust each attorney has received a copy of the report, and I'll ask the state if they have any objection to the criminal history as stated therein.
No objection, Your Honor.
And I trust no objection by the defense, Mr. Pate?
No objection, Your Honor, and I did discuss that with Mr. Apple prior to today.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Court will ask at this time, Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Apple case this afternoon?
I know of none, Your Honor.
Mr. Pate, are you aware of any such legal reason?
I know of no reason, Your Honor.
Mr. Apple, do you know of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
Court will proceed further then. Counsel, I am aware that there's been a motion for a departure sentence filed by the defense in this case. Court is familiar with its contents. Mr. Pate, you may proceed further in regards to that motion for a departure sentence.
Thank you, Your Honor. In this case, obviously our recommendation would be that the court grant a dispositional departure and place Mr. Apple on community corrections probation for a period of 36 months. I've really stated out all the reasons for that in the motion. I did also, prior to this hearing, submit to the court a letter from the Butler County Jail from the Getting Ahead class showing programming that Mr. Apple had participated in. I submitted a psychological evaluation to the court dated December 26, 2024 that Dr. Jared Steffen completed. And I also sent a letter from Cynthia Suter, who is Mr. Apple's grandmother, dated February 25th, written in support of him. She's a retired circuit judge from Missouri. I would also, as I'm sure the court and counsel has seen, just direct everyone's attention to the letter that one of the victims, Patricia Apple, wrote that's also attached to the pre-sentence investigation. I think that the biggest thing here, and I think Dr. Steffen does a really good job of setting it out in his evaluation. Mr. Apple is not, I guess, the typical criminal defendant that we see, especially in a violent person crime type of situation. He was 30 when this happened. He had no criminal history whatsoever. He does have some pretty serious mental health issues. He's been diagnosed with bipolar disorder. I think if you review the affidavit in this case and you review the evaluation, Mr. Apple was clearly not in a good state of mind when this occurred. I think he was hearing voices. Specifically, Dr. Steffen noted that his psychotic and manic mental state adversely affected his abilities to perceive, judge, reason, and control his behavior in a rational manner. Mr. Apple was experiencing extreme mental and emotional disturbances that substantially impaired his capacity for judgment and to conform his conduct to the requirements of law. That is one of the non-exclusive departure factors that's specifically set forth in KSA 21-68-15. I think it's important to note Dr. Steffen did not have the opinion, and we are not arguing that this is a mental disease or defect case where Mr. Apple did not have the ability to understand the difference between right or wrong. We're not making that statement. The report does not establish that. I think Mr. Apple understands and understood the criminality of his conduct. I think he was just in such a bad mental state that it made it difficult to conform his conduct to the requirements of law. So I think that's supportive of the specifically enumerated departure factor. As I said, he's also engaged in programming in the Butler County Jail. He completed the Getting Ahead While Getting Out class, which was a 10-week program. Ms. Apple, the victim in the case, wishes for Gage Apple to get mental health treatment rather than a prison sentence. I don't think Mr. Apple is an inherently bad or dangerous or violent person. I think he's an individual with severe mental health issues that is going to need treatment, and he's going to need medication, and that's going to exist whether he gets probation today or whether he goes to prison for several years and gets out and he's on post release. He's going to need that to be successful. I think given his mental state, I think he's probably going to be subject to manipulation and victimization in prison as well, more than the typical inmate. I know Mr. Apple has indicated to me that he wants to get back in programming with South Central Mental Health. He's willing to follow the recommendations that Dr. Steffen has set forth, which include completing an anger management program and domestic violence treatment program, and also to engage in substance abuse treatment. Mr. Apple does have a history of some substance abuse, and like we often see, I think when you combine the substance abuse and the mental health, it exacerbates those issues, it complicates them. So it's going to be absolutely critical that he stay sober and get the treatment necessary to do that. I would note to that end, he served 236 days in jail, so almost 8 months. That's, number one, been a substantial sanction and restriction on his freedom, especially for a person that is 30 years old and doesn't have any criminal history. It's also been a substantial period of forced sobriety. And I think rather than just sitting there and twiddling his thumbs, I think he's been trying to do everything he can to better himself, so when he does get out, he would be successful. So for those reasons, Your Honor, we're asking the court consider imposing probation. If the court does that and wants to give Mr. Apple a lengthy underlying sentence, I think that would be appropriate and understandable. If for some reason the court does not grant probation, our formal request would be for counts 1 and 2 to run concurrent, and the court to also consider a durational departure. But as I said, our primary request is a dispositional departure, and if the court grants that, we think whatever underlying sentence the court deems appropriate is acceptable to the defense.
Afraid several questions arise. Let's look at it first from a question of statutory authority. This is a presumptive prison case. What mental health confined facility exists that this court has the authority to make a direct placement into?
I don't necessarily think there's a confined facility that's available to him immediately. I think if he did have one available, I think the court could order him to do that as a condition of his probation. I'm not aware that there's a bed waiting for him, and that wasn't necessarily our request that he be sent to a confined mental health facility. We were thinking more along the lines of medication management, getting back in with South Central Mental Health, going to therapy, taking substance abuse treatment, and things of those nature. But I do think if there was a confined mental health facility available and he was ordered to complete that as a condition of probation, I think he would be more than willing to do that. I think that would be much more beneficial to Mr. Apple than prison for a number of reasons that I've already stated.
And how would this court be assured that there is such a facility that would accept Mr. Apple?
I don't think there's any
direct placement. Then how am I assured that he will ever go to such facility?
Well, I think he would have to make application to such a facility. I think in that case, the court could order up to a 60-day jail sanction prospectively from today to allow time for that to take place. And then once a bed is available, grant parole from those 60 days or allow him to go just simply at the expiration of 60 days.
All right. I'm also concerned here, Mr. Pate. Obviously, the underlying facts of this case is that Mr. Apple stabbed his grandmother multiple times in the face and head area. In fact, embedded an ice pick into her skull at one point. An extremely violent offense in which the victim herself called evil. This court agrees. So how does your plan, which is essentially release Mr. Apple into the community, how does that protect society, Mr. Pate?
Your Honor, if he's maintaining sobriety, if he's engaging in treatment, if he's following recommended medication management, I think those safeguards would ensure community safety. I think from what I see, his actions here were a product of a severe mental disturbance. I think you look at an individual who's 30 years of age, he has no prior criminal history at all. Usually in the typical violent person felony case that I see, you usually see a long criminal history where a person has escalated from minor drug offenses, property offenses on up, and then they graduate up to really serious things like this. I would say in my experience, it's a very, very, very rare case where you see a person that's 30 years of age with a clean record that just starts off with an aggravated battery that was originally charged as an attempted murder, unless it's a crime of passion or something like that, which this isn't. I think it was a product of Mr. Apple hallucinating, hearing voices and things of that nature. So I think his history would dictate, if we're managing the mental health thing of this very, very closely, that he's not a person that's likely to commit repeat violent offenses.
Very well, Mr. Pate. Mr. Sweeney, what is the state's position regarding this departure request?
Your Honor, the state stands in opposition of the departure request. I'm in receipt of all of the documentation that Mr. Pate has referenced regarding Dr. Steffen's report. And I don't deny, or I don't take issue with the fact that he may and probably did have some mental health issues going on at the time, maybe exacerbated by some drug usage. But that's something that we see in a lot of defendants that come through this court and other courts. And it doesn't absolve them or at least it shouldn't, from an appropriate punishment. And given the incredibly violent, brutal nature, the courts addressed what the facts of this case were. An ice pick that was used to attack his grandmother on or about her face and in her head. It's incredibly violent. And I would note and acknowledge, because I've seen the documentation from Miss Apple, and we've had contact with Miss Patricia Apple, that she wants a probationary or rehabilitative order from this court. And I can certainly appreciate that as his grandma. She loves her grandson, but I have to look at the public safety at large, and just given the incredibly violent nature of this offense, I don't think public safety is benefited if he's given a non-prison sentence. So the state would be asking for the prison sentence to be imposed, and would stand in opposition to dispositional and or durational departure.
I understand the state's position, Mr. Sweeney. Mr. Pate, anything further regarding your request for a departure sentence? I will be asking you for formal recommendations later, but anything else on the departure?
Not as to the departure, Your Honor.
Very well. Thank you. The court will ask at this time then, are there any victims present who desire to address the court in relation to this sentencing? Patricia, do you wish to address the court?
Yes, I do.
All right, you may make your statement at this time.
I want to start by thanking you, Judge Rickey, for giving me the opportunity to speak and for the professional manner in which you've handled the difficult aspect of this case. But also the respect you've shown Gage throughout. Those who've known Gage for over the years would never have believed him capable of doing what he did on July 24th, 1924. It was a shock to everyone. Gage has always showed me nothing but love and respect. If it wasn't for mental health reasons, I know in my heart we wouldn't be here today. The version of Gage present that day was not my grandson. The look in his eyes were the most completely lost, and it seemed as if he didn't even know who I was. For 30 years, Gage has been nothing but good to me, and breaks my heart that he couldn't get the sufficient help he needed through the attempts, even though he had made attempts with Butler County Mental Health. I'm sharing this in hopes that you will consider giving him concurrent sentence so that Gage will be one step closer to getting proper help he needs. I also ask that the contact with me won't be restricted anymore. For having the family support through the time is very important. I do also want to take a moment to make it known how proud I am of my two youngest grandsons who were outside of the house during the incident. It weighs heavy on my heart for what the boys went through that day, and forever be thankful for the help that my two little heroes got me. Now it's time for our family to heal, and I just pray you do the right thing for Gage. Thank you for listening.
This is tough because he has schizophrenia and he wasn't taking his meds. So yeah, it's on him. And yes, he absolutely should face the consequences. But he needs mental health treatment. If he's medicated, he can be a great guy. And the problem is keeping him medicated. Because the meds work so good that people stop taking them. He absolutely... Oh, I think they said he's both. Maybe I'm wrong. But the bottom line of it is there's an underlying mental health component. And absolutely, I think he needs to face the consequences. 100%. Because it's not okay to do what he did. But on the same token, he absolutely he needs to be medicated.
Thank you for your statement, Ms. Apple. Finding no other persons to address the court in relation to this sentencing in the nature of victims or victims' family members, court noting the court has received some written document submissions that have been referred to earlier, which the court has and will consider. The court at this time will ask counsel for their formal recommendations regarding an appropriate sentence for Mr. Apple, beginning with Brett Sweeney on behalf of the state.
Thank you, Your Honor. Your Honor, with respect to count one, the state would recommend the standard and mid-box 41 months and DOC. With respect to count two, the state would recommend the standard and mid-box 12 months and DOC. We would acknowledge he does have 236 days of jail time credit. He would have a 15% maximum good time percentage on count number 1, as well as 20% on count number 2. He would have a post-release supervision duration of 36 months on count number 1. Your Honor, pursuant to the plea agreement, we're not seeking any fine in this case. We are, of course, seeking the court costs, attorneys and bids fees if the court would find appropriate. And this is a first-time felony, so the state's seeking a DNA fee. This is, of course, a registration offense. I know he's been in custody, but I do think that needs to be addressed. As far as, no contact with the victim, his grandmother, obviously the state's asking for prison. I don't know that the state would have, if he's being sent to prison, I guess that's kind of out of the court's hands. But I don't know that the state would have any objection to him having contact with her inside the confines of Kansas Department of Corrections. Given the nature of the plea agreement, I don't think I have any further recommendations.
Very well. Thank you, Mr. Sweeney. Mr. Pate, your formal recommendations regarding an appropriate sentence.
Your Honor, our primary recommendation would be the court grant the departure, place Mr. Apple on community corrections for a period of 36 months, with 15% good time on count 1, 20% good time on count 2 if prison is imposed, and then 36 months of post-release. We agree he would be entitled to 236 days of jail credit. In the event the court grants the departure, we would leave the underlying sentence to the discretion of the court, whether the court thought concurrent or consecutive was appropriate. In the event that the court thinks prison is appropriate, we would ask the court to consider a durational departure to an appropriate sentence less than the mitigated number of 38 months on count 1, with count 2 to run concurrent. In the event the court does not think a durational departure is appropriate, we would ask for 38 months on count 1, with count 2 to run concurrent with a 12-month sentence, I suppose. I think I already said it. In that case, there'd be 15% good time count 1, 20% good time count 2, and then 36 months of post-release.
And your fees in the representation of this client, Mr. Pate?
They're approximately $2,200. So I think that's at a level where I'm going to have to ask for an exceptional order.
Very well. Understood, Mr. Pate. You've articulated your position and the position of your client well, Mr. Pate. I'll now turn to Mr. Apple himself, and I'll ask the defendant if he has any statements that he wishes to make on his own behalf in mitigation of punishment, or Mr. Apple, anything else that you wish to present to the court.
Yes, sir. If you don't mind.
Okay.
Okay. Bear with me. The first one that I have, if it's okay, I want to start out with an apology to my grandma. I know everyone knows her as my Nana, but I just wanted to say this to you. This is from my Nana, Patty Apple, and anyone else affected in this case. I am so sorry that there aren't words to describe how truly sorry I am. I pray for you all day and every day. This trauma has changed our lives forever, but I hope you can forgive me one day. I'll never be able to forgive myself. I'm haunted by this event every day forever. You are my best friend, someone who I can talk to and share memories with. You've raised me, and I would never imagine causing you or anyone any harm. That day I felt a huge part of myself died. The anger took over and I felt I was a little possessed. I'm not sure how, but I want a life, a chance at life. And I'll do whatever it takes to have another chance. God, I need you now more than ever. My deepest apologies. God bless you, and I hope you are well, Nana. And then I just wanted to read this for the courts. Thank you, Your Honor, for hearing me out and allowing me to say a few things on my own behalf. Growing up, I found myself associated with people who exhibited some unhealthy negative behaviors that led to my own struggles in my own life and my mental health In 2018, I sought out a way to get off the alcohol in an attempt to break the chains of my addiction. I started seeing a med provider on a monthly basis where I was ultimately diagnosed with anxiety, depression, the major depressive disorder, bipolar, mania, meds for PTSD. This gave me perspective on how much I needed treatment. Living all my life up to that point undiagnosed made me aware of how much this has affected my own life as well as those around me. My clean date from my drug of choice is June 21st, 2018. In jail, I have participated in the AA groups, the Thrive reentry class, and Bible study on a weekly basis. I've put together some contact information for Oxford houses and halfway houses, as well as jobs in the area that hire people with a record. Wichita workforce, temp agencies, and support groups. Upon release, I plan to work ASAP and open to school to better myself for the future. I have some previous employers that I will reapply for, such as Walmart and Sam's Club. Within the first 3 months of being released, I will have ordered a driver's license and other documents to help me get a job. Once I know more about a sentencing and potential release date, I can reach out to all of these resources listed above, which would include like bed dates at the Oxford houses and what their immediate availability would be to have me move in as a tenant. Thank you for hearing me out once more. And I do want to state that since I've been here at the jail, I have continued to make my medical lady down here, I'm sorry, the nurse down here, she has been in constant dealings with my doctor at South Central Mental Health. She's the one who advocated to get me put back on the medications and stuff like that. And, you know, after last year, I was weaning off and then getting back on the medications. Then I ended up in the hospital for 15 days in their psych unit. And, you know, that was because I was getting off the meds. Thankfully, I've been able to get back on those meds and have them monitored by psychiatrists in Wichita. I don't know all the list of the names, but I see someone, at first it was on a weekly basis, sometimes more than once, but still up to this point on a regular basis. The only thing that I could think of would be Good Shepherd, but that's not really a place that's going to do anything more than, I've been there a few times before for like detox and getting put on medications. But long term, since I have all the medications and stuff that I was on prior to, I'm back and I've been stabilized. When I got to the jail here, I weighed 106 pounds. They immediately put me on 24-hour watch because my body mass index was so low. And since then, I weighed in a couple of days ago, this last week, I weighed in 143 pounds. I have never been this healthy in my life. And the support that I have here at the jail has been astounding. So I just wanted to say thank you for hearing me out. And I just wanted to say, because I haven't seen her face, I am so sorry and I love you so much. I just want to hug you. I just want to hug you. Because tomorrow was never promised and I hate this. Oh, I'm supposed to be home with you, taking care of you. And I'm so sorry to you and I'm so sorry to the boys. It's just an awful thing. So I'm so glad you were able to be here. Anyways, I hope you're safe. I hope you're well. I hope all the good things. And I know that I don't have any words. Nana, you don't deserve this from me or anyone. And I'm so sorry. I am so, so sorry.
All right, Mr. Apple. The court's ready to pronounce sentence in your case. The court's giving you some latitude at the end of your statement to make some statements of apology to Patricia Apple, your grandmother, which she's certainly entitled to under the circumstances of this case, and I'll give you a certain amount of credit for doing so. Mr. Apple, I tend to agree with what Patricia once labeled your acts as, and that is evil. Somewhere there was an evil in you that was unleashed that day that caused you to take an ice pick and try to stick it through your grandmother's eyes and lodge that ice pick into her head after multiple stab wounds. That is not threatened harm. That is very, very serious actual harm that was done to another human being, especially one that you had every reason to love. What a sweet lady she is. To come to court and advocate for you after what you did to her. What a wonderful woman. She deserved better than the treatment you gave her that day. The court has to judge your actions here. And I will say, Mr. Apple, after everything's been presented, and I've read everything that's been presented to the court, that the court wishes to show you mercy. The court wishes to show you compassion. This court also has to weigh, however, your threat to society, which the court considers to be considerable, even as we speak. The court will go ahead and start pronouncing its sentence at this time. The court hereby establishes count 1 as the base sentence in this case for the offense of aggravated battery, a severity level 4, non-drug person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 4I. The court hereby sentences the defendant to a term of 38 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed. Regarding count 2, for the additional offense of aggravated assault committed with a deadly weapon, based on court finding that the ice pick used in this case was a deadly weapon, the court finds that this is a severity level 7, non-drug person felony. The court imposes 12 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant is eligible to receive 20% of good time credit and would be subject to 12 months post-release supervision on that charge and charge alone. However, the court will at this time run the counts and the time on counts 1 and 2 concurrently with one another. So there is a controlling sentence in this case of 38 months. Mr. Apple, your attorney, as I stated earlier, and sorry about the loss of video, that was unintended. Your attorneys argued well on your behalf for a departure. I do note all of the statements in support, including your grandmother, Patricia. However, this court, despite its wanting to show you mercy and compassion, also has to look, as I stated earlier, on the protection of society. For this probation plan that Mr. Pate argues for today to work, a lot of voluntary things would have to take place where this court would have to count on your willingness and consistency in performing those things. There are issues about where you would live, where you would work, what kind of treatment program you'd be in, and whether you would voluntarily participate in a long-term mental health treatment program and take the medications that have been prescribed, especially with your long history of substance abuse. These all, in this court's view, create problems with any probation program that might be established. This court is bothered tremendously, Mr. Apple, and this is not necessarily your fault, that the Department of Corrections does not have a facility that is centered solely on mental health treatment in a confined setting. You would be a poster child for placement in such a facility. But no such facility exists. What we have is a correctional system, a prison system, or you're out in the community. And this court has to resolve today which of those two is better in this case. The court makes the ultimate determination that there are no substantial and compelling reasons for this court to grant a dispositional departure in this case. The legislature has determined that someone in your grid box who's committed a level 4 serious felony crime is to be presumptive prison. There's not enough here to overturn that statutory presumption. And the court finds that the court will deny the request for a dispositional departure in this case. This court has granted the minimum sentence under the Kansas guidelines for sentencing in this case. I've run the counts concurrently with one another, and I've granted you the mitigated sentence in this case of 38 months. And also noting that you've already served 236 days, about 8 months of that sentence, and you do have the eligibility to earn good time credit toward that sentence. So it's not going to be a very long prison sentence, Mr. Apple, but this court is going to follow the statutory presumption in this case and order you to serve your time in prison. And that is a controlling sentence of 38 months. I don't think there's a request here for restitution to the victim, Mr. Sweeney.
That's accurate, Your Honor.
All right. Of course, already dealt with the issue of jail time credit. The court awards 236 days, I think is the proper computation as of today. And the sentencing journal entry should reflect the 236 days jail time credit. I will remind Mr. Apple of his obligation to register as a violent offender for a period of 15 years under the Kansas Offender Registration Act, dealing with periods where you are not incarcerated. I'll advise you, Mr. Apple, that you someday may have the right to seek expungement of these offenses. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant has a right to appeal their convictions to an appellate court having jurisdiction. And if such defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Apple, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. Mr. Apple, I'll remind you that there's prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. The court will be assessing a felony docket fee in this case, and I think it's still appropriate for this court to assess to the defendant a $200 DNA fee. The court will waive bids, amounts, and all other costs given the court's prison order that it's made here today. Mr. Sweeney, I'm looking at my notes from this sentencing proceeding. Are you aware of any other sentencing related matter that the court still needs to address or readdress?
No, Your Honor.
Mr. Pate, are you aware of a sentencing related matter that the court has not yet addressed?
Is the court also considering and denying any request for a durational departure?
That was implicit in the court's announcement of its sentence, Mr. Pate. The court has denied a durational departure in this case.
Thank you.
All right. With all of that said, Mr. Apple, I do see in you a current willingness to take advantage of any programming that's available to you to get yourself better. I highly suggest that you continue to do that. First of all, that type of participation in programming in Department of Corrections custody will help you earn those good time credits against your sentence for an earlier release date. Furthermore, I would like to think that you're going to be in the best possible shape when you're released back into the community, so something like this never, ever happens again. Good luck in that regard, Mr. Apple. I hope you're successful in participating and doing well in those programs.
Thank you, Your Honor.
All right. Patricia Apple, I do appreciate your appearance here today and your addressing the court. Good luck to you in the future, ma'am. All right. If there's nothing further, then Mr. Apple will remain in the custody of the Butler County Sheriff's representatives until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 38-month prison sentence that's been imposed here today. There's nothing further. The Gage Apple matter will currently be in recess.
His Nana is a rock star. Oh my gosh, I forgot a 5 at the end of that. So yeah, it's supposed to say January 16th, 25, but it doesn't. Oh, glorious days. I guess I'll have to fix that for the replay crew mini. Yeah, for her to show such grace and forgiveness is just astounding. I can't even. Of course it would be, Mortimer Duke, my love. Of course it would be. Yep, 38 months, the minimum that Judge Ricky could grant. Wow. That's really cool. No, she has, there were actually 2 other grandchildren there at the house the day that it happened, and they're the ones that, called for help and saved her life. Oh, Mortimer Duke, I love you. Look at Bandit. Bandit loves you too. Thank you so much. Honey, I can see the picture in the corner. I'm wondering if it's settings on your end possibly. Because I can see myself. I turned the resolution all the way down. Let me see what it looks like if I turn the resolution all the way up. Give me a second here. Okay, how is that in comparison for you? Because it doesn't look as good on this end. I don't use any. I don't use any. It's a new camera. Hold on. I don't know what to do. I'm sorry. There is, I put the Logitech app on. That's what I was doing when I lost camera function, and I'm afraid to do things. Hold on, image adjustments, filters, original adjustments, auto exposure. Let's go down a ways. Hold on. I'm gonna minimize. Hold on. I'm trying, guys. Give me just a second here. I'm making some adjustments. Let's go down a little ways in brightness. All right, I'm gonna see now. It's gonna take just a second for my camera to come back, I think. But I did. I may have to just go get a new camera. I don't know, guys. Give me a minute. And that might be too, because it's a new monitor. It's much bigger, much bigger. So I don't. It should have come back by now, I would think. Oh. Reload this page to apply your updated settings. I might go away for 2 seconds, guys. I'll be right back.
This is in the
It didn't help, but we're gonna carry on. I'm gonna just we're gonna just pretend that everything's hunky dory. Okay, we got past that one. Silly date.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Taylor Parite. It's case number 2024 CR 473. James Watts appears as defense counsel. Amber Norris as prosecuting attorney. Taylor Parite appears eventually by his own Zoom. Mr. Parite, we need to clear something up right from the start. You were in court on November the 25th, where this hearing was set. And you were specifically told that you needed to appear at the Judicial Center in El Dorado or at your attorney's office. Now, I'm sure that I was clear and unequivocal about that. One of the reasons why I require that is to avoid the very type of technology.
I had a family emergency.
Just a minute. To avoid the technology issues that you experienced this morning with an inability or fumbling around to try to join us by video and audio. That could have been avoided if you would have appeared at one of the two places that I ordered you to appear. You've decided on your own not to follow the court's order, and quite frankly, Mr. Parite, I don't like it. Do you have an explanation?
I had a family emergency.
A family emergency. You know, it's just amazing to me, Mr. Parite, how many family emergencies pop up when somebody has a court date. Well, I'm very happy with you, Mr. Parite. And I hope we don't struggle with technology the rest of this hearing, because you are supposed to be in your attorney's office. Mr. Watts' technology is very, very reliable, as well as the judicial centers. I can count on it. I can rely upon it. Where are you at right now physically, Mr. Parite?
I'm in Houston, Texas, at
Houston, Texas.
on my way to Indiana.
Do you have a restriction on your bond not to leave the state of Kansas?
Yes, sir.
So you violated that order too, right?
Yes, sir.
All right, what is the business we're to conduct here? This is set for evidentiary preliminary hearing. Mr. Watts?
It was, Your Honor. I've had a chance to speak with Mr. Prees this morning. Ms. Norris had made a proposal yesterday afternoon by email about resolving this matter. It's my understanding Mr. Prees wishes to accept that offer. That would be counts 2 and 3, identity theft and misdemeanor theft, dismissing count 1.
All right, Mr. Parite, implicit in that, and I trust that is what you're intending to do today. Is that correct?
Yes, sir.
We're going to deal with the issue of preliminary hearing so I can let these witnesses go. All right, Mr. Parite, do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes, sir.
You understand that if you waive preliminary hearing, the court will bind you over for trial at this point without any further determination of probable cause?
Yes, sir.
You understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later?
Yes, sir.
Have you had an opportunity to consult with your lawyer before making a decision to waive?
Yes, sir.
And do you now freely and voluntarily waive your right to a preliminary hearing in this case?
Yes, sir.
Does the state of Kansas waive its right to a preliminary hearing, Ms. Norris?
Yes, Your Honor.
Court finds that both parties have knowingly waived their rights to a preliminary hearing. Defendant is bound over for trial on any and all felony charges of the information. In light of the court's acceptance of that waiver, I can release all witnesses that were subpoenaed to testify this morning. I do greatly appreciate your patience this morning as we got started and for your attendance here today. But I can go ahead and let you leave the meeting at this time.
Thank you, Your Honor.
Thank you.
Thank
you.
Thank you, Your Honor.
Thank you, Your Honor.
Did I lose my defendant?
Yes, Your Honor.
I'm going to presuppose he's going to try to get right back on.
Your Honor, just spoke with Mr. Preet. He's signing back on right now. And there he is.
All right, I will note for the record that Mr. Preet has now rejoined this proceeding by Zoom. Mr. Preet,
Yes, sir.
what happened?
The lost connection.
Lost connection.
It looked to me like he tapped out.
Hope we don't lose connection again, Mr. Preet.
Yes, sir.
All right, it's been announced that you're now going to accept conviction by pleading guilty to 2 of the 3 counts in this case. Count 2 being identity theft, a level 8 non-person felony, and count 3 theft, a class A non-person misdemeanor. Is that what you intend to do?
Yes, sir.
But I've got a whole series of questions I need to ask you regarding the taking of a felony plea. If there's anything asked of you that you do not understand, I will give you the opportunity to confer privately with your lawyer. I would have greatly preferred that you be in his office right now, where it would be much easier for you to confer with him. But since you've elected not to follow the court's order and you're participating very, very remotely, I hope we don't have any technology issues, Mr. Preet. State your full legal name for the record.
Taylor Marpery,
How old are you right now?
28,
What's the highest level of education that you've attained?
high school.
You believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
Sir?
Do you think you're going to have difficulty understanding any of the legal matters that we're going to be discussing here
sir.
this morning? All right, let me finish my question before you begin to answer, okay?
Yes, sir.
Have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health meds that you are not currently taking?
No, sir.
So, Mr. Preet, it's my understanding that your mind is clear and that you have a full understanding of what's going on here in court. Is that the case? I didn't hear you.
Yes, sir.
Did you receive a
Yes, sir.
copy of the original charging document in the case, Mr. Preet?
Yes, sir.
Do you understand the nature of the charge in count 2, identity theft?
Yes, sir.
Is your vehicle moving?
Yes, sir. I'm not driving.
Pull over. Find a safe place to pull over.
I'm not driving.
I don't care. Pull over.
All right.
I don't want to get motion sickness watching you on screen. This is a serious matter, Mr. Preet. You don't seem to be taking it seriously at all. All right, Mr. Preet, do you understand the nature of the charge of theft?
Yes, sir.
You understand that when you enter pleas of guilty, you are admitting the acts charged in counts 2 and 3 as alleged by the state.
Yes, sir.
And you also understand that when you enter a plea of guilty, you're giving up any legal defenses that you might have had to those charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Watts, and that at a trial, you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you would have a privilege against self-incrimination, which means that you could get up on the witness stand under oath and tell your side of the story at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, sir.
You understand that by entering a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, sir.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
Do you understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, sir.
Now, are you aware of the sentences that could be imposed as a result of these guilty pleas that you're attempting to make?
Yes, sir.
All right, well, let's go over those. Identity theft is a level 8 felony charge in the state of Kansas, Mr. Parikh. On the level 8 line of the non-drug offense grid, in the most favorable criminal history category of I, you can receive as little as a 7-month sentence. However, in the most serious criminal history category of A, you could receive up to a 23-month prison sentence. So the sentencing range is 7 to 23 months in prison, depending on your criminal history. Mr. Parikh, as you sit in the car today, we do not know with certainty what your criminal history is. You, better than anyone else here, ought to know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research, as of the date of your sentencing, that will determine where you fall along the level 8 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
Mr. Parikh, though a great deal of that grid line is presumptive probation, if you have 2 or more person felonies on your record at time of sentencing, you will be presumptive prison here. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense.
Yes, sir.
Count 3 is a Class A non-person misdemeanor. Do you understand that that's punishable by up to a $2,500 fine and up to 1 year in the county jail, or both?
Yes, sir.
You also understand that as a direct consequence of this plea, you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
Do you also understand that you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, sir.
You also understand that the Kansas Sentencing Guidelines Act has many special sentencing rules. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? You understand that, Mr. Parikh?
Yes, sir.
Did you have an ample opportunity to discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
Do I need any more time privately?
Yes.
No,
You need to talk to your lawyer before we go on.
No, sir.
Are you satisfied with the services and advice given to you by your attorney?
Yes, sir.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
No, sir.
You understand, Mr. Parikh, that if there have been any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So how do you plead to the charge in count 2, identity theft, a level 8 non-person felony?
Guilty.
And to count 3, theft, a class A non-person misdemeanor?
Guilty.
According to the state's charging document, this all took place October 13 of 2024. Is that when it happened?
Yes, sir.
And it was somewhere in Butler County, Kansas. Where was it?
In El Dorado.
Okay. What did you do that would constitute identity theft, Mr. Preet?
For the per diem card.
What?
The per diem card.
Okay. I can tell you what the charging document says, Mr. Preet. You apparently used Jonathan Medina's name and date of birth. Did you do that?
No, it was a per diem card.
Okay. I'm not sure what you're saying.
It's a card we get at work.
Okay. So you used someone else's card?
Yes,
And
sir.
what did you do with that?
I pull cash off of it.
Okay. And you didn't have permission of this Jonathan Medina to do that. Is that correct?
Correct.
Okay. According to count 3, you took or stole $853 and a wallet and its contents. Is that right?
It was just cash.
Okay. And you used Jonathan Medina's name with the intent to defraud that person or someone else. Is that correct?
No, sir. Never to defraud him.
May I inquire, Your Honor?
Excuse me?
May I inquire, Your Honor?
You may.
Mr. Pre, this was a per diem card for expenses while you're working at turnaround at the refinery. Is that correct?
Correct.
Okay. In order to take money off, that per diem card is assigned to a particular individual. Is that correct?
Correct.
Okay. In order to take money off of that card, in this case, the card belonging to Jonathan Medina, you would have to essentially claim to be Jonathan Medina. Is that correct?
Correct. Correct.
Okay. And in that way, you would basically defraud someone by claiming you are someone that you were not, correct?
Correct. Correct.
Will that assist, Your Honor?
It will. Mr. Medina, do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for the crime charged in count 2, identity theft, a level 8 non-person felony, and count 3, theft, a class A non-person misdemeanor?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court shouldn't accept Mr. Preet's plea?
No, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Preet, do you know of any legal reason or any other good reason why the court shouldn't accept your pleas here this morning?
No, sir.
Court will accept the guilty pleas made by the defendant and finds that those pleas are made voluntarily. He has an understanding of the nature of his charges and the consequences of his plea. The factual basis for each charge does exist. The court finds the defendant guilty and adjudges him therefore convicted of the crime charged in count 2, identity theft, a level 8 non-person felony, and count 3, theft, a class A non-person misdemeanor. Count 1 is dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Mr. Preet's criminal history, and the court will set an appropriate date for sentencing. Earlier, Mr. Preet, you talked about El Dorado, Kansas. Do you know where El Dorado, Kansas is?
Yes, sir.
Okay. You seem to have forgotten that today when you were supposed to have been there. But your sentencing will be with you being present in El Dorado, Kansas, and nowhere else. Do you understand that?
Yes, sir.
I'd like to sentence you right now if I could, Mr. Preet, but there needs to be a pre-sentence investigation to research your criminal history and deal with some other matters. That generally takes about 2 months. So I'm going to look for a court date about 2 months out. Counsel, I'm currently looking at Wednesday, March 12th. Mr. Watts, Ms. Norris. I have some flexibility on time on that date, March 12th.
I can do that, Your Honor, about any time the court wishes to do it.
Ms. Norris?
Your Honor, if we could go either later in the morning or at least after maybe 2:30.
All right, would 11 o'clock a.m. work?
Yes, Your Honor.
All right, I will set the sentencing for Taylor Preet Wednesday, March 12th, 11 o'clock a.m. Taylor Preet is ordered by this court to be personally present at the Butler County Judicial Center in El Dorado, Kansas, and no other location. I need you to repeat that back to me, Mr. Preet. Where do you need to be?
Butler County Judicial Center,
And what
11 a.m.
city and state is that?
El Dorado, Kansas.
All right. I'm still very displeased you didn't follow the court's order before, Mr. Preet. We had a late start and complication because you didn't. Quite frankly, I just want to get you to sentencing. You are ordered to fully comply with any pre-sentence assessments that are necessary in this case. I'm going to need you to immediately contact Butler County Court Services Department and follow their direction as to what you need to do to facilitate the pre-sentence investigation. You're going to have to perhaps do some assessments or some testing. I don't know,
Yes.
but you're going to need to follow their direction. Do you have something to write down, a phone number, Mr. Preet?
Yes, sir. Hold on.
Okay, I think you're going to need to call the number of area code 316, I think is the
All
correct one.
right.
Did you get that? Mr. Preet?
Yes, sir.
Okay, would you repeat the number back to me, please?
Yes, sir. I got it.
Repeat it back,
316
please.
322.
Correct. If you'll call that immediately after this hearing, you'll talk to someone from the Court Services Department and then follow their direction as to what you need to do regarding this pre-sentence investigation process.
Yes, sir.
Okay? And do that right away. Then I'll need you in El Dorado, Kansas, Butler County Judicial Center for sentencing Wednesday, March 12th, 11 o'clock a.m. All right. Mr. Watts, are you aware of anything further we need to address here?
I don't believe so, Your Honor. Thank you.
Ms. Norris, anything further at this time?
No, Your Honor. Thank you.
All right. Mr. Preet, do you have any questions about what we've done here this morning?
No, sir.
All right, Mr. Preet, make that call, then you can get back on the road. There's nothing further then. The Preet matter is in recess.
And now we get to go on to the update. Yay!
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Taylor Preet. It's case number 2024 CR 473. Amber Norris appears on behalf of the state of Kansas. James Watts as defense counsel. Defendant, contrary to the court's earlier order, does not appear at the Judicial Center, but rather is appearing from some remote location. Where are you, Mr. Preet?
I'm currently in a rehab.
Okay, and do you happen to know the city and state of your rehab?
Monroe, Louisiana.
Okay. We'll get into that here in just a moment.
Yes,
Matter
sir.
comes before the court at this time for a scheduled felony sentencing, the court noting that on January 16, 2025, the defendant appeared remotely, reportedly in Texas at the time. The defendant at that time pled guilty to count 2, identity theft, a level 8 felony, and count 3, theft, a class A misdemeanor. Pre-sentence report was ordered. The defendant was ordered to comply with all assessments. Sentencing was set for today at 11 o'clock. Defendant must appear at the Judicial Center, no other place. Defendant admonished for not following the court's orders and appearing by Zoom. Furthermore, court has received a report from Court Services Officer Christine Donovan. That date to report is March 6, 2025. I'll read it into the record. The defendant is scheduled for sentencing on March 12, 2025 at 11 o'clock a.m. for identity theft, a level 8 non-person felony, and theft, a class A non-person misdemeanor. Attempts were made to contact the defendant by telephone and mail to schedule an LSCMI interview, but he has not responded. The pre-sentence investigation is incomplete as a result. Christine Donovan, Court Services Officer. Do you, other than the emails that you sent yesterday, Ms. Donovan, I'm aware of them and their contents, what is the current status of the pre-sentence report? Have you conducted a criminal history on Mr. Parikh?
Your Honor, I have. I, just so the court is aware, I've also had contact with Mr. Parikh and his counselor as well, and I have scheduled the LSCMI interview for March 20th at 1 o'clock. So they are going to help facilitate that at the program he is located at currently. And with that being said, I would just ask for some additional time to complete the PSI after that.
All right, based on your research of criminal history, where will Mr. Parikh fall into a criminal history category?
Your Honor, I have a lot of out-of-state records for him currently, and I want to follow up on those because it appeared that most of those were pending cases, and I don't want to commit to his criminal history until I just verified that none of them were actual convictions, and they are all in the state of Louisiana.
All right. The court is at least curious regarding how Mr. Parikh, who reportedly was in Texas in January, is now in Louisiana, apparently subject to Louisiana court or tribal court orders detaining him, placing him in a rehab facility. How did you get to Louisiana, Mr. Parikh? Unmute yourself and explain.
I live in Louisiana.
Were you in Texas in January, like you represented to the court?
Yes, I was visiting my father, who had a doctor's appointment at MD Anderson.
How long do you expect to be in your current facility?
Over here, I'm gonna be here for 90 days.
And when did that start?
Admission was on Taylor. It was on admission was on 3/3.
Admission was on 3/3.
You haven't been there very long.
I was in another facility before that.
What is the state's position here, Ms. Norris?
Your Honor, obviously we don't have the PSI, so we can't proceed with sentencing. It sounds like he is under orders from another court. I'll leave it to this court's discretion on how you wish to deal with his bond. But it does sound like we're at least going to be able to get the PSI completed, and they're going to help facilitate the LSCMI or LSIR, whichever form they're using at the moment.
Mr. Watts, as defense counsel, what is your position here?
Your Honor, we'd ask the court to set this matter off until after the PSI is completed. It sounds like his release is in June. So he's unable to be here physically until June, until that release. Whether I see Mr. Parikh shaking his head, are you still not going to be able to be here?
Your Honor, this is, and Mr. Watts, this is Ashley Kinman. I'm his social worker, appointed social worker with the Tunica Biloxi Tribe of Marksville, Louisiana. Just to kind of clarify and give you guys a little bit of update on how things function here on the tribal federal grounds and in our parish, which is county. Mr. Parikh was arrested with some charges with the local county and got pre-sentenced. And before hearing, he was arrested on
Okay,
trial.
we've lost audio on Ms. Kinman.
Can you hear me?
I can hear her just fine, Judge.
As can I.
Maybe I've just lost audio.
I'm sorry, just let me know when you can hear me.
I can hear you now.
Okay, so following his local arrest, he was arrested on tribal grounds. So myself and our tribal judge worked with our local district attorney, and in lieu of sentencing time, we agreed to put him on a case plan and a restricted detainer into facilities to that would adhere to his mental health and his substance abuse treatment. However, in the state of Louisiana, we do not have local providers that will do a 12-month straight program. So he has gone into a multiple phase program. He has completed his first phase, which was, I think, a 60-day program of intense inpatient lockdown, UA screens, counseling, anger management classes, so forth. He graduated that, and now he's in his second program, which is another program that is subject to be 90 days to continue his treatment, but he does have a little bit more freedom versus a lockdown. He is able to communicate with family, but he is responsible to seek other outside treatment along what he's getting. If he successfully graduates that in 90 days, he will then proceed to the next phase. Our local county and federal judge did a detainer up to 12 months. So he is committed. If he violates that, then he will be sentenced and incarcerated in the state of Louisiana. I hope that helps. If you have any questions, I know we do things a little bit differently here. One of the advantages of having him being a tribal citizen is we have the funding and the capability to assist him in his addictions and his poor choices that he's made. Now he has to suffer consequences, but unfortunately our local jails are not beneficial. So we're giving him the benefit of the doubt, and we're at our last straw here. He has been cooperative. He has been compliant. He's passing these drug screens, but he will, even after these 12 months, our federal judge will do a continuation of a treatment plan that may be modified, but he will continue to be followed by our services up to 2 years.
Very well. Thank you for your statement to this court, Ms. Kinman.
Yes, sir. Thank you.
All right. Ms. Donovan, based on the current schedule with the LSCMI on March the 20th, what would your reasonable projection be as to when that report will be ready for purposes of rescheduling this sentencing proceeding?
Your Honor, I would ask for at least 3 weeks from today.
Certainly seems like a reasonable request. It looks like Mr. Parikh's scheduled to be right where he is right now when we reschedule this case. I'm going to address my assistant for a moment. Mandy, do I have 1:15 on Wednesday, April 2?
Yes, Judge.
I will propose that date and time, 1:15 p.m. Wednesday, April the 2nd, Counsel. Mr. Watts, if you're talking, I can't hear you.
Yes, sir, I can do that.
Okay. Hearing no objection from the state. Excuse
Your
me?
Honor, you still are allowing him to do this via Zoom and not in person.
Yes,
Okay, thank you.
yes. I think requiring him to appear here would probably disrupt more and cause more problems than what it would solve. I do appreciate your involvement here. It does appear that Mr. Parikh's part of a monitored long-term program,
Yes, sir.
generally centered around making him better,
Yes, sir.
and the court doesn't want to interfere with that currently.
Thank you. I appreciate that. It really means a lot to myself and Mr. Parikh.
I don't think that Judge Rickey can trump a federal judge, but I am happy that this defendant is off the streets for a year or longer if he doesn't comply.
Also, the court obviously is putting a great deal of weight in the fact that documentation has been provided to this court that he's currently under a detainer from a federal judge.
Yes, sir.
So that assures the court that this isn't something voluntary that Mr. Parit's doing to avoid responsibilities here in Kansas, but rather he just simply submitting to the authority of the state of Louisiana and getting help in the process.
Yes, sir.
So 1:15, Wednesday, April 2, by Zoom. Mandy, for simplicity purposes, can we use the same Zoom numbers that we did today?
They won't be available, Judge.
Okay. Well, I'm glad I asked then. You'll all receive a new Zoom invitation. Do you have Ms. Kinman's email address, Mandy?
No, but I think Christine does. Okay.
I do, Your Honor.
All right, Christine, would you provide that to Mandy so she can
Yes,
make
I
sure
will.
that Ms. Kinman is able to coordinate Zoom for Mr. Parit?
Yes.
All right. Mr. Watts, as defense counsel, are you aware of anything else that we need to address today?
Not at this time, Your Honor. Thank you.
Ms. Norris, as prosecuting attorney, anything further at this time?
No, Your Honor, thank you.
Mr. Parit, do you have any questions about what we've done here?
No, Your Honor. Thank
All
you
right.
very much.
All right. Make sure that you're on the Zoom meeting at 1:15, Wednesday, April 2nd. Make sure you comply with the rules of the facility that you're in.
Yes, sir. Thank you, Your Honor.
And furthermore, last but not least, I'm going to expect that you fully comply with any pre-sentence assessments which are still necessary, including this risk needs assessment that you're going to be doing on March the 20th at 1. Okay?
Yes, sir, Your Honor.
All right. We'll see you Wednesday, April 2nd, 1:15 p.m. by Zoom. If there's nothing further, the Parit matter is currently in recess. This meeting may be ended for all.
Well, I am here, guys. I know you can't see me. It has a nifty little reload button on the top. But I think I did that already once. If I do it again, it is going to kick me back out again. But the case is over, so hang tight for 2 seconds. It didn't work. It did not work at all. Grrr. I'm going to have to play with it. It says dream. I am the avatar. All right, guys. I'm going to let you go so that I can try to fix this and come back better tomorrow. I'm sorry. Thank you guys for coming out. I'm glad, Mortimer Duke, that I could fulfill that sentencing case for you. Yeah, I'm really happy I was able to give you guys that FTC. That guy he got under my skin. I really do think that his whole plan with going to the different states, I mean, he clearly was violating those bond conditions. They could have gotten him on that. They didn't. I think Ricky was going to give him the smackdown, though. I really do. So, I'm trying. Now that it doesn't take 45 minutes to export a case, I can rock more content out. That means I can start coming on in the daytime and spending time with you guys. I love you so much too. Thank you. All right, guys, you're just going to have to imagine it tonight. But be safe, be well, sleep sweet, and much love.